On Montreal Now, a tale of a tussle over a will. 3 brothers lose their mother. Significant size estate. One of the brothers decides he deserves a greater share than what was provided for. Here to tell us the story is CJAD 800's legal contributor, Chris Dimakos. Hi, Chris.
Hi, Trudy.
What's the rest of the background to this story?
Yeah, so it's not uncommon to have siblings fight over an estate, but usually what we see is there's a lot of I would say claims that are addressed towards the parent. The parent wasn't in the right state of mind when they made the will, or the parent didn't reflect their true wishes in this will. This time, though, however, there was a different legal approach. One of the 3 sons that was set to receive an equal partition of the estate said, I'm not contesting the fact that our mom, intended to have all 3 of us receive equal shares, but in doing so, it's unfair because I'm the one that maintained her house. I'm the one that took her to the doctor's appointment, since I'm the one that had to care for her. And by doing so, my brothers benefited from it financially. They didn't have to pay for a home. They didn't have to take her to the doctor. They didn't have to conduct these repairs on the home. So they're unjustly enriched. So a little bit of a variation on how this individual tried to contest the partition of will, not so much from the mom's intent, but more so from, hey, look, if we leave this as is, my brothers are unjustly enriched, and therefore I should get more of a share just because I assumed more of her expenses and more time and care for her. So that's the approach that was taken to the courts, and they had to battle that out, which is a little bit different from the usual approach.
What was the difference between what the will provided for him and the share he thought he deserved?
So, for example, the will didn't provide for anything regarding any costs. So, for example, if there was work to be done on a window or a leak or a door, or maybe the driveway needed to be repaved, or whatever the case may be, nothing in the will provided for that. But this son took it upon himself to pay for those expenses, only trying to get that money back after the will came into effect. So what the courts ruled in this case was saying, it's fine and dandy that you had those expenses, but these are things that should have been discussed beforehand. If you felt that they should be contributing to those expenses, you should have sat down with your brothers and told them that work needs to get done. How are we going to pay for this? Instead of doing the work, paying for it, and then trying to claim it back from them afterwards. And the court said, we don't vary a will because the real essence of a will is to respect the last wishes of the deceased. It's not an accounting of what take place afterwards. So again, so many disputes take place because tough discussions are not had beforehand. And if you can find it in you to have those discussions beforehand, it eliminates a lot of pain and a lot of conflict, and especially legal costs and courts and expenses that you don't want to have afterwards. You want to be able to just grieve and not have to deal with all this stuff. But that being said, this individual was unsuccessful. Basically, the court said you did so because you wanted to, and you took care of your mom because you wanted to, and you can't have the will varied just because you took on the lion's share of that responsibility. If you didn't want to do it without getting compensated, it should have been discussed beforehand.
This was a multi-million-dollar estate, so obviously he felt that it was worth his while, I guess, to go to court and pay the legal fees. But I think this happens in a lot of families where you have one of the offspring who is the primary caregiver to an aging parent, maybe simply because they live closer, or, and the other siblings live in other cities, or maybe they have that person living with them, and so the caregiving falls to them. If the courts had gone the other way, that would have opened up a possibility for a lot of people to contest wills. I'm not surprised the court ruled in the way it did.
Well, it's a great point you bring up, because the opposite is sometimes true as well. I've had experiences where I've seen an elderly parent who changes the will based on who is providing that type of care, bringing them to the doctor's appointments and caring for them, and it's their right to do so. I mean, it's their asset, it's their estate. They can do as they want with it. But you're absolutely right. It does take place, and I've also seen sometimes when there's unresolved conflict between siblings and the parent, the last remaining parent is deceased. Sometimes it's almost understood that they're going to lose touch once and for all. And it's almost like this is one last way to bring people, to keep them, even if it's under really tough circumstances, to keep them in each other's lives. And I've seen that before. I've seen one sibling say, I have some issues with you, and we're not going to let this just go the way it goes. And they're willing to pay hundreds, if not thousands of dollars to try and, I wouldn't say penalize, but try to express to them how unhappy they were when the parents were alive with the whole family dynamic. So it's a very emotional situation when you're involved with estates law. There's a lot of emotion there, and sometimes the grounds and the motivation behind lawsuits is not necessarily financial. It could be just conflict, unresolved conflict that they want to hear someone like a judge say, "You're right, they were wrong," and if the parent didn't do it, well, they're looking for that approval from the judge.
In this particular case with that multi-million-dollar estate, did it indicate how much, in terms of cold hard cash, that son would have walked away from it if the ruling had gone his way? Would have walked away with?
So I would say that in the facts, because the decision was from the appeal court, so the appeal court doesn't look at the actual detail. They look more at whether or not the judge of first instance made an error in judgment, and in this case, they said they didn't. But just to give you an idea, what was partitioned was about $3 million, so $1 million each for each sibling, and I'm not sure what the exact claim was, but it definitely wasn't for millions of dollars. It was for a smaller amount, and I have a feeling that the fact that it was for not such a large amount, it had a lot to do with principle and with someone seeking kind of like a retribution and saying, "Hey, I'm the one that should get more here. I'm the one who did the most and who sacrificed the most for our parent. You shouldn't be walking away with the same amount as I did just because I took care of her. I repaired her house." So a lot of times it's an issue like, "Hey, you shouldn't be getting the same amount as me. I did more for our mom than you did." And sometimes children look for that, even if they're adults. They look for that type of approval with the way that these estates are handed out. So again, a lot of emotion when family dynamics are very complicated, and a lot of times they fall onto a judge's desk and they have to try and resolve this, this issue in a case where things have been developing for years and years and years. So it's not an easy task for the judge. I can say that.
For the rest of us who might not have multi-million-dollar estates, what's the path forward? What's the moral of the story for us out of this ruling? You've talked about how this stuff has to be worked out ideally beforehand. What if you're estranged from your siblings and they won't hear any argument you're making that you're going to need money to take care of mom's roof or to get her in-home care or something like that?
You're absolutely right about that. In many cases, it is the case where they're estranged. They don't have a good relationship. They don't communicate. But I could say this. You have an option, lesser of two evils. Do you want to go through that difficult situation by writing an email and saying, "Hey, here's what we have to deal with. I want to talk to all of you before I make any decisions on what you're comfortable with," or you can deal with it afterwards. And afterwards means lawyers' letters, fees, going to court, being sent a subpoena to have to fly to Montreal to deal with an estate. I would tell you, I know it's difficult, but even if you're a parent, and you have children and they are, there's a discussion that comes up, you want to have that discussion with your kids beforehand, because if it comes from the parent, if you can explain to the kids, "Hey, this is why I'm doing this," it avoids the whole, lawsuit and, "No, she didn't want that," or "He didn't want that. I know what they wanted." And then they start spending all this kind of money to determine whether or not the true wishes were respected. So To answer your question, Trudy, I think the hardest part is to have that conversation beforehand, but it resolves so much if you can. And it's okay if it's difficult, and it's okay if there's a little bit of emotion that gets done, but I'd rather have that situation. I recommend to everyone, have it beforehand so that you avoid having to fork over a significant portion to the lawyers and the court costs. You don't want that situation. I can tell you that.
Good advice from Chris Dimakos. Thanks very much, Chris.
Thanks, Trudy.
Chris Dimakos is CJAD 800's legal contributor.